Good afternoon, everyone. Welcome to the first program in our antitrust webinar series, Navigating Global Competition Law Challenges in Turbulent Geopolitical Times. This is a series designed for Japanese and other Asian companies who are focused on success in their cross-border investments. Can we start the slides, please? Next slide, please. I'm Marcia Goodman, and I'm a partner in our Chicago office and our practice working with Japanese clients. I will be your moderator today, and I'll introduce briefly our speakers. Our speakers today are U.S. antitrust partner Rachel Lamort from Washington, D.C., UK and EU competition partner Daniel Bowden from London, and corporate M&A partner Allison Lee from Hong Kong. Next slide, please. In the US, we have an upcoming presidential election. In the UK and Europe, we've had recent game-changing elections. Political change does affect antitrust enforcement, especially for merger control. As everyone involved in cross-border investment knows, antitrust and competition considerations can interfere with deal completion. Today, our speakers will share their insights on how to foresee those risks and how the company investing from abroad can conquer those risks to succeed in their deals. The pending Nippon Steel acquisition of U.S. Steel continues to draw a huge amount of attention, both in Japan and the U.S. The political effects are reported in the news every day. We won't be addressing the Nippon Steel acquisition directly today, and we won't be addressing the antitrust aspects of the proposed acquisition of Japan's 7-Eleven either. But the points we will be talking about are highly relevant for both and will be relevant to your investments today and going forward. I'll turn the program over to our speakers in a minute, but just before we do, as the presentations go on, you may have questions, and I'd ask you to put your questions in the Q&A tab, and the Q&A tab you can find by clicking More, the three dots on your screen. We've also posted information about how to enter your questions in the chat in case, and so you can look at that at any point. At this point, I will turn things over to our first speaker, Rachel Lamort. Rachel, over to you.
Next slide, please. Thank you, Marcia, and welcome, everyone. As Marcia said, my name is Rachel Lamort, and I'm an antitrust partner in Mayor Brown's Washington, D.C. office. I'll be discussing the U.S. merger control system today. Next slide. Now, as many of you know, the 2024 presidential election will impact competition enforcement policy in the U.S. Why is that? The president sets out competition policy and priorities for the U.S. Those policies and priorities are carried out by two agencies, the Department of Justice and the Federal Trade Commission. Those are the agencies that enforce competition law. The president appoints the head of each of those agencies. Most relevant to our discussion today, deals of certain values, or in the case of deals that are outside the U.S., where U.S. turnover meets a certain threshold, are reviewed by the Department of Justice or the Federal Trade Commission. This merger control process gives the enforcers a period of time in which to investigate and clear the deal, or if the enforcer thinks the transaction is anti-competitive, sue to block the transaction entirely or clear it with conditions. Next slide, please. Now, these decisions, whether to block a deal or not, are guided by the president's competition enforcement priorities. Historically, it was fairly simple to predict a president's approach to deals based on his party. So, as reflected on this slide, Democrats were more likely to challenge transactions. Republicans were less likely to challenge transactions as anti-competitive. You saw this difference between President Clinton, a Democrat, and President George W. Bush, a Republican. Merger challenges rose during the Clinton administration and then decreased during the Bush administration. President Bush challenged fewer than half of the transactions that President Clinton did. But parties started to become a less predictable proxy for approach to deals after the financial crisis in 2008. So President Obama, a Democrat, promised to reinvigorate antitrust enforcement, and competition investigations of transactions immediately rose, but then they leveled off. And this leveling off occurred even though transaction activity during the Obama administration was at an all-time high. The environment was fairly friendly to deals among competitors and transactions involving firms at different levels of the same supply chain. Now, experts thought that the Trump administration would be even less likely to challenge deals as anti-competitive, but enforcement was actually quite uneven. So at first, the Trump administration was challenging deals as anti-competitive at about the same rate as the Obama administration. But then, starting around the midpoint of his administration, President Trump became more aggressive in targeting certain types of deals. So his administration became very interested in tech transactions, and it also became very interested in transactions among entities that don't compete. Those transactions that are among companies at different points in the same supply chain. The Biden administration built upon this approach and has taken a fairly aggressive approach to deals. The Biden administration proposed rules to make merger control filings more complex. It has sought to block entirely deals that it thinks are anti-competitive, rather than clearing them with conditions, for instance. And the Biden administration built on the Trump administration's focus on tech transactions and transactions among non-competitors. But the Biden administration also focused on issues that the Trump administration had not focused on. How transactions affect competition in labor markets, for instance, and transactions by private equity firms. So what does that tell us about what to expect after the 2024 election? Next slide, please. So most importantly, party is no longer everything. Whether Donald Trump wins or Kamala Harris wins, close scrutiny of deals during the merger control process is here to stay. And regardless of who wins, Kamala Harris or Donald Trump, some things are probably going to stay the same. Changes to the merger control filing rules in the US are likely to go into effect. Competition enforcement will continue to focus on tech transactions. And a promise by firms engaged in a deal to change their conduct after the deal is probably not going to be enough to get a deal done. But there will be some differences depending on who wins. A big question: who's going to lead the Federal Trade Commission? An architect of the Biden administration's policy has been the chair of the Federal Trade Commission. The vice presidential candidate running with Donald Trump likes her. What does Donald Trump think? We don't really know. Another big question: will transactions in consumer-focused industries be a priority for an administration? Will scrutiny of private equity firm transactions continue? Will deals be blocked because of the impact on labor and employment markets? Will cross-border cooperation continue at the same level? Those are some of the issues that we're going to talk about today. Next slide, please. First, let's talk about something that's likely to be the same regardless of whether Donald Trump or Kamala Harris wins. And that's that the overhaul of the US merger control filing system is likely to happen. So what are these changes? Historically, US merger control filings were fairly simple and are fairly simple compared to other jurisdictions. But in June 2023, the Biden administration proposed rules that would make the US merger control filing much more detailed. Parties will have to provide narrative descriptions of the transaction, parties, industries affected by the deal. And for the first time, parties will have to provide draft documents evaluating the deal and its impact on the relevant industries and also the employees of each firm. As a result of these proposed changes, firms should expect to spend more time and money putting the filing together, and then clearance is likely to take more time because it will take enforcers longer to review the materials that have been submitted. Why are these rules likely to go into effect regardless of who wins the election? proposed rules of this type take a long time to finalize and a long time to rescind. So we presume that Kamala Harris wants these rules to go into effect. The Biden administration proposed them, and the reason for that, they say, is because it will give them more information to aggressively scrutinize deals. But even if the Donald Trump administration wanted to rescind these rules, they couldn't just do that. They'd have to go through a long process to replace them, and that can be difficult to pull together. But this, you'll notice we're talking about proposed rules. When will they go into effect? As noted on the timeline, they were proposed in June 2023, and it's 18 months later, and there are still no final rules. We just don't know when they're going to go into effect. In April, enforcers told us to expect rules within weeks. We heard some rumors in August that the rules would be finalized by the end of that month. At this point, we are expecting them to be finalized by the end of the Biden administration, but they're rapidly running out of time. So we'll have to stay tuned to see how quickly the Biden administration can release the final rules. Next slide, please. Regardless of who wins, we should also expect competition enforcers in the US to continue to focus on tech transactions. Now, we saw a focus on tech starting during the Obama administration, but the Obama administration was viewed as fairly friendly to innovation and did not challenge any of the big tech deals that really became before the administration during that period of time. The Trump administration increasingly focused on tech transactions, particularly toward the end of his term, and sued to block some fairly high-profile deals. For instance, in 2017, Department of Justice sought to block telecommunications company AT&T's $108 billion acquisition of media and entertainment company Time Warner. The Trump administration also brought litigation outside of the merger control space against Google. And what we know about Donald Trump's vice presidential candidate, J.D. Vance, is that he's very vocal about his criticism of big tech. Now, the Biden administration has also challenged its share of tech transactions. Most notably, the Federal Trade Commission sought to block Microsoft's acquisition of Activision Blizzard, for instance. Now, we expect this focus to continue, again, regardless of whether Kamala Harris or Donald Trump wins. But one important thing to keep in mind is that Kamala Harris is the former senator from California, and she has ties to Silicon Valley. So it is possible that that will lead her to take a more nuanced approach to tech transactions. Perhaps it'll be an approach more similar to the Obama administration, but we'll have to wait and see. Next slide, please. Regardless of who wins, we're unlikely to see much change as to what companies need to do to get their deal done. So one way enforcers decide to work with companies to get a deal done is to get them to change their behavior in some way. Say the firms agree to a long-term license or other contract that will allay competition concerns. These are called conduct remedies. And this option was favored by the Obama administration, but it's probably not going to make a comeback. That's because they've been criticized by both the Trump administration and the Biden administration. Now, there may be some differences between Kamala Harris and Donald Trump in their willingness to negotiate with firms to get a deal done, aside from conduct remedies. The Biden administration has been fairly skeptical of settlements and has preferred to block deals entirely. It carefully scrutinizes divestiture partners. We'd expect Kamala Harris to take a similar approach, but that's different from what we saw during the Trump administration, which agreed to settle transaction reviews with divestitures by the parties fairly regularly. Next slide, please. Now, we do expect other differences between Kamala Harris and Donald Trump in their approach to merger control review. So first, again, who's going to lead the Federal Trade Commission? If Chair Lina Khan stays, she takes very aggressive positions on antitrust enforcement. If she stays in the position, expect close scrutiny of deals. Kamala Harris has announced that she wants to focus on consumer-facing issues. She recently made clear that she was going to crack down on large transactions in the food industry. Transactions in other consumer-focused industries like healthcare and pharmaceuticals are also likely to get attention during a Harris administration. But Donald Trump has made no indication that he is similarly interested in those types of deals. We can also expect interest in private equity firm transactions if Kamala Harris wins. So the Biden administration has shown a lot of interest in serial acquisitions by private equity firms in particular industries. And we don't expect this to change. This scrutiny is not just of deals that require merger control filings. Smaller transactions that are below the reportable thresholds have been of particular interest to the Biden administration. And this type of scrutiny could expand beyond private equity firms to transactions by conglomerates with multi-industry holdings. Finally, we should expect a Harris administration to continue the Biden administration's focus on transactions' impact on labor and employment markets. That is, if the courts let her. So that the idea that transactions can lessen competition in markets for workers is a somewhat novel theory in the United States. It's not apparent that US courts will allow the government to challenge mergers on this basis. In particular, we're watching two cases the Biden administration has brought on this very theory. In both, the Federal Trade Commission is arguing that the transactions in question would allow the combined firm to increase leverage over workers. If the courts allow these labor market theories to continue, we expect a Harris administration to bring more cases on this basis. The Trump administration, on the other hand, has shown no interest in challenging transactions on that basis. Next slide, please. Before my colleagues talk a bit about merger control review and getting the deal done beyond the United States, I'd like to say a few words about what we should keep in mind about cross-border deals as relates to the US. Over the past 2 decades, there's been closer and closer coordination among competition enforcers around the world. This has been regardless of the party of the president in the United States. And some examples of this cooperation are listed on the slide. But firms in the US have complained about this type of cooperation. In a recent transaction, the Federal Trade Commission was criticized by allies of the Republican Party for working with foreign regulators to block the merger. The Trump administration, as a result, may change its approach and coordinate less across borders. And we should also keep in mind that a Trump administration's foreign policy may affect merger control for cross-border deals. For instance, during the last Trump administration, Donald Trump's trade war was blamed for the collapse of the Qualcomm NXP deal. That deal had competition clearance in all jurisdictions except China, and the Chinese enforcer refused to approve it. Now, a President Harris would likely be more internationally minded, and this might make the clearance process proceed more smoothly for cross-border deals. In sum, there's a lot to keep in mind as we look ahead to deal making after the election. And I'll be pleased to answer any questions you have about this topic later in our presentation. With that, I'm pleased to turn this over to my colleague, Daniel.
Thank you very much, Rachel. If we could move, fantastic, to the next slide. It's a privilege to address you all today. My name's Daniel Bowden. I'm head of the antitrust practice here in London. I was also previously based in Brussels, and that means I can speak from experience about recent trends in Europe and in the UK. And similar to the United States, here in Europe, here in the UK, we have witnessed dramatic political changes, and we are witnessing rising geopolitical tensions. And these make for a dynamic, uncertain legal situation that could present challenges for deal makers. If we could go to the next slide, please. On this first slide, I want to talk about the broad political landscape, and the slides that follow we'll talk about specific developments you need to be aware of for M&A planning purposes. I should also mention I have a cold, so you may have to bear with me while I cough and splutter momentarily. Turning first to the EU, there were elections in June 2024 for the European Parliament, and we saw notable successes for populist and right-wing political groups across Europe, most notably in France, which led President Macron to call snap elections in France, which ultimately proved inconclusive. And these elections matter because the term of the current European Commission ends this year. So we're going to see the appointment of a new leadership team, a new European Commission with a new political program and a new legal agenda. Indeed, at least in theory, we should actually have an announcement tomorrow on the appointment of the new commissioners. So that means we will discover, in principle, tomorrow who is going to succeed Margaret Vestager as the new commissioner for competition. And whoever that is, the new commissioner will have a specific mandate, a specific set of goals for his or her term in office. And that means the direction of travel in the EU is about to change. In the UK as well, we saw elections earlier in the year, and those brought to an end 14 years of Conservative rule. We now have a new UK government, a centre-left Labour government. And that government is going to oversee some significant reforms, and most particularly, I've called out in the slide, the Digital Markets, Competition and Consumers Act. I intend to talk about the UK last. I'm going to talk about the EU first. So if we could please go to the next slide. Going into the detail of recent developments, I'd like to start with Illumina Grail. And honestly, I'm not sure you could start anywhere else. This is probably one of the most controversial EU merger control cases in recent memory. It reached a conclusion just last week with perhaps the most eagerly awaited European Court judgment in the last 20 years or so, certainly as far as merger control goes. Before discussing the judgment, the case needs to be set in context, and to do this, I'm going to very briefly consider the structure of the EU merger regulation, which takes me to the first bullet. Jurisdiction under the EU merger regulation is established applying bright line turnover tests. What does that actually mean? It means a filing is required only where merging parties have worldwide and EU-wide turnover that exceeds certain stated levels. If you have turnover above a certain level, if the target business you're looking at has turnover above a certain level, you are obliged to make a filing in Brussels, and completion of your deal must be held in abeyance until you have approval from the European Commission. And the use of clear-cut turnover thresholds provides you, me, the international business community with legal certainty. Article 22 of the EU merger regulation provides an exception to that general rule. It was originally included to assist EU member states that didn't have their own national merger control rules. And those member states could refer transactions to the European Commission so that it could consider deals effectively as their proxy. And it would be no surprise to learn that the Article 22 referral system was used very rarely indeed. And then in 2021, there was a dramatic change of policy. And this was due to fears around so-called killer acquisitions. You've probably heard that term many times. I'm afraid I'm going to explain what that term means one more time, so please bear with me. Killer acquisitions are acquisitions, characteristically in technology or pharmaceutical markets, where an incumbent player, an existing player, buys an innovative startup company or a recently launched company. And this is with a view to eliminating future competition. And the great concern has been that these startup companies, these recently launched companies, of necessity, they have very little turnover. And as a consequence, there was an enforcement gap under the EU merger regulation, under national laws where turnover tests were used to establish jurisdiction. In response to this problem, the Commission encouraged member states to use Article 22 to refer below threshold deals to it. And Illumina's acquisition of Grail, that was the very first below threshold deal referred under the revised Article 22 policy. And that decision, the policy more generally, they were enormously controversial. They were seen as causing great harm by reducing legal certainty and predictability. And that lack of legal certainty had real-world practical consequences when it came to evaluating deal risk, preparing transaction documents, planning deal timetables. There was a risk of European Commission intervention that you couldn't necessarily predict or exclude very easily. If we could go to the next slide, please. The Illumina Grail story spans many years, and the facts of the case are particular to the case, and I don't want to talk about them. What's of broader interest is the policy and the process that the companies are subject to. And this current slide that's on the screen, it tries to tell a complicated story very simply by outlining a few key events. And I want to just flag a few of these for your attention. In June 2021, the Commission began its investigation of Illumina Grail. And in September 2022, it banned the transaction. And although the deal was prohibited, Illumina decided to complete the transaction in defiance of the European Commission. And as a result, Illumina was fined 432 million euro in 2023. That is a record-breaking fine, the largest fine ever imposed in an EU merger control case. Now, in those circumstances, you won't be surprised to hear that Illumina appealed to the European courts. And as recently as Tuesday, 3rd September, the Court of Justice issued a final ruling. And I'm glad to say it's good news. If we go to the next slide, please. Thank you. The Court of Justice overruled the European Commission in all important respects. And I'm going to discuss the detail of the ruling in just one moment. But there is one point that the court stresses repeatedly in its judgment that I want to call out to you. The court says companies are entitled to do deals, to conduct mergers and acquisitions subject to rules that are certain and predictable and which respect the rights of business. A key quote from the judgment is included on this slide, which encapsulates this sentiment. The Court of Justice struck down the Commission's position on Article 22 referrals because it, and I quote, undermines the effectiveness, predictability, and legal certainty that must be guaranteed to the parties to a concentration. In other words, merging parties. And it seems to me this is a victory for common sense. This ruling is a vindication of the rights of deal makers like you. So if we go to the next slide, please. So I mentioned I was going to go into the detail of the judgment a little bit more. The Court of Justice ruled that the revised Article 22 referral policy was without proper legal justification. It was illegal. The Commission had effectively exceeded its powers by amending the EU merger regulation. That's something it can't do alone. It has to act in concert with other EU institutions to enact legislative change. As a consequence of all this, just last Friday, the European Commission cancelled the 432 million euro fine it had imposed on Illumina. That fine lacked any proper legal basis. So all of this, what does it mean for you when you are considering M&A activity? It means that legal certainty and predictability have been restored. It means you and your professional advisors can plan with confidence. It means you'll only need to consider an EU merger filing if the applicable turnover tests are met. So it's good news for you. It leaves the European Commission with a real challenge because the problem of killer acquisitions has not disappeared. And at this very early stage, the judgment only came out last week, there seem to be 3 options which are being actively considered by the antitrust agencies. First, they may try to apply antitrust rules to below-threshold transactions. And speaking frankly, that is fraught with legal difficulty, so I'm not sure that's going to be practicable. Second, the EU member states themselves may revise their national merger control rules to capture below-threshold acquisitions. And third, there is the possibility of legislative reform to amend the EU merger regulation itself. So I would urge you to closely monitor developments. And at the moment, if I was going to place a bet, I would be betting that at least some of them at the EU member states will revise their merger control rules and adopt new tests, most likely some sort of size of transaction test to capture below threshold transactions. We'll have to wait and see. We go to the next slide, please. I want to conclude by talking about the UK. We have a new government in the UK. We're also living the aftermath of Brexit, the UK's decision to leave the EU in 2020. And I want to pause for a moment on Brexit. It's had at least 2 short-term effects that are relevant to deal making. First, since Brexit, the Competition and Markets Authority, the CMA, has intervened much more aggressively in a number of international deals. The CMA is now independent of the EU, and it wants to be seen as a leading player on the world stage. Second, and this is a related point, the CMA can now review deals in parallel with the European Commission. And the CMA can reach different views to the European Commission on the same deals. And the case that perfectly sums all of this up is Microsoft Activision, cleared by the European Commission, only to be blocked by the CMA until the agency came under fierce criticism, including from the UK government. And at that point, Microsoft conveniently offered some additional remedies, and the CMA, in an unprecedented move, reversed its decision. So the CMA is more aggressive on the world stage. It is more interventionist. And in that context, it's important to note that the CMA is going to be granted more extensive powers. We expect the Digital Markets Competition and Consumers Act to come into force either by the end of this year or the very beginning of 2025. And in relation to merger control, it's going to provide the CMA with the ability to intervene in even more deals. In an EU context, we were discussing the problem of killer acquisitions. In the UK, this problem is going to be addressed by introducing a new acquirer-focused test. In future, it will be possible for the CMA to review a merger relying just on the UK turnover and the UK share of an acquiring party. It won't matter what the turnover of the target is, so long as that target business or target assets, they have some sort of UK presence. So I'd warn you now, if you have a substantial UK business, you may be at heightened risk when making acquisitions, even if the target business has only modest UK activities. There are some other reforms that are envisaged under the Digital Markets Competition and Consumers Act, and in the interest of time, I'm not going to linger on them over them in any detail, but the CMA is going to have more extensive penalty powers. And the one point I would want to call out in more detail is that this new act, this reform, makes it clear that the CMA's information gathering powers extend outside the UK and can apply to companies outside the UK. This is a point of ambiguity. There's been some court cases around all of this, but it's now, any ambiguity has been resolved. If you are a business based in Japan, it is possible for the CMA to send you an information request and compel you to comply with that information request as a matter of English law. So overall, the demands of the UK merger control system on foreign companies are about to increase. We can move to the next slide, please. My final slide. I want to talk about FDI, foreign direct investment controls, and the implications for deal makers. In relation to foreign direct investment controls, the UK has led the way, introducing wide-ranging new screening system in 2022. The acquisitions of businesses or assets relating to certain sensitive sectors require notification to the UK government for prior approval. And the regime is really very wide-ranging in scope. In the last financial year, more than 800 notifications were made under the UK FDI rules. And to set that in context, by contrast, the Competition and Markets Authority considered 53 Phase 1 merger control cases in the same time period. Critically, the UK rules can apply to foreign deals where the target business supplies sensitive goods or services into the UK. So the acquisition of a target that is not resident based in the UK can still fall within the scope of the UK FDI rules if that business is making supplies, selling goods or services into the UK. An important point to note. Given rising geopolitical tensions, reforms were made to the UK FDI regime early in the year, but we can now anticipate much more ambitious and wider-ranging reforms under our new UK government. There is widespread discussion, speculation about what the government might do. It hasn't shown its hand yet, but certainly there seems a real risk that it may extend the scope, the breadth of these sensitive sectors where notifications are required. It has indicated that it is going to intervene more robustly. So reform is the key theme in the UK. And it's also a theme in the EU, where the European Commission published an ambitious reform programme earlier this year. Reform in relation to FDI in Europe is just beginning, and the appointment of a new European Commission may change the trajectory that's taken. But I'd urge you again to monitor developments closely. Reforms are likely to take effect in 2026. And with that, I'm going to hand over, please, to Alison.
Great. Thank you, Daniel. Good afternoon, everyone, and thank you for joining us today. I'm Allison, an M&A corporate partner resident in our Hong Kong office. I advise on cross-border transactions and JVs across the Asia Pacific region, which includes both inbound and outbound Japanese M&A transactions. So we now shift our focus to Asia and take a look at recent deal activity and transactions in this part of the world. And then we'll turn to look at some tips and considerations for you when you are conducting your M&A deals, given the current competition and increasingly complex regulatory environment. Next slide, please. So this is an interesting graph. We start here with a look at M&A deal activity over the last 5 years, both globally, which is on the left, and in Asia Pacific, which is the chart on the right. As you can see, M&A transaction volumes have dropped globally since the peak of 2021, but relatively more dramatically in Asia. Deal values have also dropped more significantly in Asia, although overall it's consistent with the flattening out of deal values globally. This is sobering, but probably not particularly surprising to our attendees because due to volatile currencies, persistent higher for longer interest rates, inflationary fears, as well as a lot of uncertainty arising from the US and global elections and the broader geopolitical landscape. Next slide, please. Interestingly, this is a slide that shows M&A trends in Japan and the number and value of M&A transactions for Japanese companies from January to June of this year, so first half 2024. The red figure on the left is the number of outbound transactions where Japanese companies are the buyers, which have taken place. The light blue figure is the number of inbound transactions where foreign companies are buyers. And the dark blue is the domestic transactions where both buyers and sellers are Japanese companies. Interestingly, in contrast to the global and regional trends, here you can see that figures year on year comparatively for Japanese companies seem rosier and more active, with inbound, outbound, and domestic M&A transactions all showing an increase in volume, which is the number of deals. And for the value of M&A transactions as well, in contrast to the prior chart, both inbound and outbound transactions have increased significantly. And you can see that it's a nearly 50% increase in inbound transactions and a nearly 150% increase compared to the first half of 2023 for outbound transactions. Next slide, please. This next slide is a breakdown of the identity of the countries into which Japanese investors are buying, or the outbound investments. As you can see, just first half of 2024, the vast majority of outbound M&A deals in Japan are with the US companies, followed by Singapore and India, then by the UK and EU, notably Germany and France. The presence of Singapore and India high up on this list is also not surprising, given the focus on growth and development into Southeast Asia and other growing economies in the region, as well as the fact that countries have been seeking for hedges and differentiators from China. Without doubt, this is also why the regulatory and administrative policy changes in the US, the UK, and the EU are areas of focus for our webinar today, are of really great importance to Japanese players. Next slide, please. So now that we have that backdrop, we turn to some practical considerations for you to keep in mind as your company considers M&A transactions in this current environment. Next slide, please. With these new enforcement trends and regulatory developments, antitrust counsel are key to M&A teams navigating challenges and getting the deal done. Next slide, please. So here we outline some practical suggestions for you to keep top of mind. First and foremost, and we really can't emphasize this enough, you have to involve antitrust counsel on both buyer and seller side actively and early. This is key to identify competition concerns, predict issues early on, craft appropriate deal terms, review documents for the transaction, and also just get good advice on best due diligence practices. It will also be very helpful as you negotiate the deal. Second is ensuring early and active coordination. Involving legal counsel early will help you ensure that you have global cooperation among your business stakeholders and that competition counsel for merger control filings, and if needed for investigations, are all involved and coordinated. And third, timing. Never underestimate the amount of time and the lengthy merger control processes that are involved. You need to allot time and plan. This allows you to work closely and effectively with Competition Counsel, with M&A Counsel as a team to develop permissible integration planning processes. The key challenge in an international transaction with multiple regulatory clearances is to be able to design, agree upon, and implement a global package with multiple authorities. Parties will need legal advisors who have strong project management capabilities, good relationships, and a thorough understanding of the regulators and the regulatory landscape, and also the resources and experience to coordinate across multiple jurisdictions. Next slide, please. And here we also outline some key considerations during each phase of the deal. It's something that should thread throughout the transaction, starting from the very beginning when you're in the due diligence or negotiation phase. During this process, a robust process should be established, which helps differentiate between the levels of sensitive information and groups of information recipients. You have to think about whether you want clean teams or very small groups of recipients for potentially sensitive information. And you always want to strike the right balance, and that will require some help and advice from your counsel as well. You want to make sure that you're not doing too much information sharing, because that could look like market collusion, or in a remedy divestment situation may invoke gun jumping considerations, while too little information sharing threatens a natural and robust due diligence process, which is needed for a good M&A process. Then in your post-completion or your ongoing operation phase, when you have a joint venture or in a shareholder arrangement, investors tend to want as much operational information, as much management oversight and control as possible. Often we'll see parties seeking board, committee seats. Here, rather than a one-size-fits-all information grab, parties should carefully consider what is really necessary. This is especially relevant for JV partners that could be viewed as market competitors, as this could lead to complications in the ongoing operations with thoughts of conflicts of interests and whether directors or committee members have appropriately recused themselves. So there's quite a few considerations there. It's not always the most obvious choice. And then with respect to exit and post-exit obligations, the typical issues of no poach, non-solicitation, non-compete agreements always come up. Here, the most careful thought should be given to terms, especially around duration and scope, as well as exceptions and carve-outs. These will be heavily negotiated. So in conclusion, there are relevant antitrust considerations for parties to M&A transactions to consider during each phase of the deal. And parties may need to rethink their customary or historic approach. We advise that whenever you're in doubt, you should reach out to legal counsel, and we'd be very happy to help answer any questions that you have. Next slide, please. So here, that concludes our prepared remarks for today's presentation, and we now move to the Q&A portion of our session. I hand it back over to Marcia to moderate the questions. Thank you.
Thank you, Allison. Let's take the slides down so everyone can see our panelists better. Okay, great. So on the questions, just a reminder that if you'd like to write a question, you can. There's a Q&A box at the bottom of your screen, or you can find the Q&A in the More button, also at the bottom of your screen. We do have a few questions to start with, so I'm going to read out one or two of them, but we'd love it if people sent us questions, and then we'll unmute you so that you can ask your own question and have a dialogue with the panelists. So we can move. We have 15 minutes in the program, and we have plenty of time to have those conversations. So let me start out with one question that was of interest from the audience, in particular regarding the U.S. What do you think is the most important thing that a company can do to improve its chances of a smooth merger control process, regardless of which party wins the US election?
Sure, thanks, Marcia. I'll echo something that Allison concluded with in her remarks. Involving antitrust counsel early in any deal is very important at any time. In particular, in looking ahead toward after the presidential election, I think we're in a period of dynamic change in the US antitrust system. And as a result, getting antitrust counsel involved early is going to help ensure a smooth merger control process. And I think in particular, something to keep in mind, regardless of who wins, we do expect new filing guidelines to go into effect. And that's going to complicate the process and lengthen the process. And so deal makers should be including competition counsel in their discussions about deals early so that they can be crafting those submissions and related deal documents in the best way to ensure clearance quickly.
Thank you, Rachel. I think that's great advice. And I'll say that in the deals that clients talk to me about, more and more they're saying, can we talk to your antitrust lawyer first? And so that we can get a sense of what are the hurdles going to be, what's the timing going to be, and let's get everything organized and not just wait for a problem to arise. Daniel, are you seeing that too?
Absolutely echo those sentiments. I mean, if you're in earnest about doing a deal, you need to identify deal risk as early as possible. And given, for instance, in the UK, the aggressive stance of the CMA, or the unpredictability of the European Commission recently, bringing in antitrust advisors so they can tell you upfront what sorts of regulatory hurdles you may need to deal with, it's imperative you get there early. You cannot wait until you've proceeded a couple of months to try to tackle any of this. So the earlier you seek antitrust advice, the better, and then you can come up with the best solutions to mitigate risk.
Great. Rachel, there's a question that occurred to me as you were talking. You mentioned that there in the US is increased scrutiny of private equity acquisitions and even serial acquisitions, that is multiple acquisitions of by conglomerates and others. Why is that an issue for the authorities?
Sure. So I think similar to what Daniel was speaking about with respect to killer acquisitions, as they call them in Europe, in the US, the Biden administration has been quite focused on ensuring continued competitiveness of smaller companies that might one day down the road become larger competitors to any major industrial player. And where we've really seen this play out in the US is with these private equity transactions. So in particular, for example, in the healthcare space, the Biden administration has quite closely scrutinized purchases of small healthcare practices, multiple small healthcare practices, that allowed private equity firms to gain fairly substantial footholds in healthcare markets around the country. And so this has been of interest for private equity firms specifically for the Biden administration, but I think you can see these lessons play out more broadly for any company that has multiple holdings in any one particular industry or across multiple industries.
Can I add, Marcia, on that front, actually? It's an excellent point to raise, because certainly in Europe, there's been less of a focus on PE acquisitions and these kind of what we could describe as serial acquisitions. So, small acquisitions all within the same sector, which in aggregate produces significant market standing. Not something that the European antitrust authorities have been looking at closely in recent years. This year, they've really kind of switched on to it. So certainly the head of the CMA was at an international conference in the US, and really inspired by the US practice that Rachel just described. I think in the UK, they're going to scrutinize these types of acquisition much more closely. And I think the expectation is that Brussels national competition authorities are likely to follow suit. So this is a sort of a new area of inquiry for European antitrust authorities.
Thank you. We have a question that just came in from the audience that might be perfect for Allison, or at least we can start with Allison on this one. And the question is, how can you structure a provision in your agreement that sorry, that I need to read the question. It disappeared. How can you structure a provision in your agreement to address antitrust issues up front? And what are the basic things that are required in such a provision? Allison, do you want to start with that one?
Yeah, sure. And then others can chime in. I think the key typically in an SPA would be the conditions. So what we call conditions precedent. And this is a very key element to any transaction. It doesn't always have to be an antitrust CP, but basically what it's saying is what must get done in order for the deal to close. And this will very typically involve, among other things, and depending on what jurisdiction you're looking at, because the US, the UK, the Hong Kong, everyone takes a different style towards what's customary. But this would be where a condition like HSR or a merger filing would be put into the transaction document. What's interesting is in the past, you typically see players kind of viewing it as whether it's a seller's burden or condition versus a buyer or purchaser's condition. But as we enter a more complex regulatory environment, you see parties proactively thinking, regardless of whether they're buyer or seller, really thinking about the issues, and regulatory antitrust would be absolutely one of those. But typically that is how it would be encapsulated. It's a condition that must be met, in this case, clearance from name your relevant authorities before the transaction will close. And there's also different obligations or standards for the parties. So what you may have heard in an M&A context would be a hell or high water provision, which means doesn't matter what happens or to what extent does a buyer or seller have to work to get that approval. And that's where there's a lot of negotiation and consideration from both sides.
Great. Anyone else want to comment on that question, or do you think we've covered it?
I think the last point you made, Alison, is a critical one, and it's why antitrust advisors need to come in early. Really, conditions precedent are a mechanism for allocating risk between the parties, and you need to understand what the risk is. And to understand antitrust risk, you need to speak to your antitrust advisors. So is the risk going to be on buy side? Is it going to be on sell side? How are you going to configure that condition precedent? You need to evaluate risk first before you can really get to the negotiating table and have a proper informed negotiation.
If I may
Great.
also add, sorry, Marcia, in addition to these conditions precedent in the US, we're seeing quite creative, different ways of allocating the risk over the course of the performance of the merger clearance provisions. So for instance, more than ever before, we're seeing, for instance, payments to parties based on whether the deal happened or not, or what performance occurred with respect to the antitrust authorities. So in the US, at least, it's no longer all in the conditions precedent. We're really seeing a lot of different creative ways to try to allocate risk between the parties in some of these more challenging transactions.
Great.
If I may sorry.
All right, one more thing. Go ahead.
Yeah, I think that's really interesting, and I'm not surprised it starts in the US, but that does speak to what we're talking about, because I think as antitrust becomes more challenging for parties to negotiate and complicated, maybe it becomes too much of all the eggs in one basket. So parties are trying to allocate the risk and shift it so it doesn't become a one size fits all, process, and all the risk is on, or all the burden is on one party versus the other.
Okay, so that takes us into our next question, which is a very interesting one. And I'm hoping all of our panelists can say something about this. The question is there anything specific in antitrust or CFIUS FDI matters that Japanese companies need to watch out for especially in Japan-US cross-border transactions, as compared to, for instance, a US company as an acquirer. If you're the person who asked the question, you'll receive a message asking if you want to unmute. So if you want to dialogue with the panelists, you'll be able to do that. Who wants to take this first? Is it Rachel?
Yeah, perhaps I'll start with the US.
Okay.
And then Allison and Daniel, please jump in. But before I do, does our question asker have anything more to elaborate on before I dive in?
Let's see. Can you, Mr. Tamura, can you unmute? Or would you like to unmute? Okay, let's say
Well,
no
sure.
other.
Oh,
yes.
Thank you.
Okay,
Thank you for reading the
please. Go
question.
ahead.
Yes, I was just thinking about if there is any advantage or disadvantage by the Japanese companies engaged in cross-border transaction in regard to antitrust or sort of CFIUS situation. Nothing specific, but if there is going to be some advantage or disadvantage, there may be a better advice that we can give to our Japanese companies who are serious and interested in closing the deal.
Sure. I don't think there's any great advantage or great disadvantage to a Japanese company doing a deal either entirely outside the US that requires a merger control filing in the US, or a Japanese company doing a deal with a US company. I think one slight advantage is likely the sophistication of the Japanese merger control process. That I have found that I should say the US filing system to date has been very, very simple, although our enforcers are quite aggressive. Putting together a US merger control filing has been very simple. That's about to change. But when I've worked with companies outside the United States, their familiarity with more complicated and complex merger control filing systems, I think makes them more attuned to the importance of organizing and communicating with Competition Council early. And I think that in particular with Japanese companies, I've observed this most keenly. So I think that's one advantage. It's not necessarily easier to get the deal done, but I think that awareness of competition issues oftentimes makes it a bit less daunting to deal with US regulators.
Okay, thank you. That's very helpful.
Just to add one comment from the CFIUS front, obviously there are national security considerations there in CFIUS, and the strong alliance between the US and Japan certainly gives Japanese companies in general an advantage over for instance, acquirers from China or other companies. Of course, depending on political winds, you might see something different, but that's the overall view of the CFIUS practitioners.
Yeah, Marcia, if I might just add something else, actually, I think that something to keep in mind, a major difference between Kamala Harris and Donald Trump is that their approach to foreign policy. And as I noted in my my planned remarks, I mean, we really did see that Donald Trump's trade war with China affecting competition review and clearance of deals, not necessarily on the US side, but outside the US. And so I think I want to emphasize what Marcia said as to the importance of the strong connections between the US and Japan, and just highlight again that these foreign policy considerations do make a difference, not always in the US, but certainly generally.
And obviously there are differences from company to company. We don't want to overgeneralize, but I think that's a general thing that you can say. Daniel, I think you may be there to make our final comment before we end at the hour here.
That's very kind of you. Thank you. A very good question. I'm from an EU UK perspective, maybe three observations. One, as a Japanese firm, Illumina Grail, the court judgment I referred to, means that you don't have to worry anymore about the risk of referral by a member state to the European Commission and review unexpectedly, even though you don't meet applicable turnover thresholds. So I think good news on that front in that predictability has been restored. Rachel mentioned the burden of different merger filings, and there is a spectrum. With the European Commission, there is a short form, a simplified process. As a Japanese acquirer, you may be able to benefit from that and have to produce very few internal documents and actually quite a modest amount of information. There's a new simplified procedure that took effect only last year, so you may benefit from that. On the other hand, however, the information burden in the UK is formidable. So I'd warn you, if you think you may have a UK filing, you need to get your antitrust advisors involved early to assist you in the preparation of a filing. Final point, FDI, CFIUS, I think, is structured so that some countries are exempted from CFIUS filings, and some countries, you know, the relations between the US and those countries mean that you may be more favorably reviewed. That same sort of presumption does not generally exist in the UK and in the EU. So regrettably, even though we have excellent relations with Japan, you would have to make a notification in the UK, for instance, under FDI rules, and you'd be subject to full scrutiny. And the warning I'd give you is that the EU, the European Commission, is trying to reform the FDI rules across all of the member states. So you may find yourself in years to come subject to more intensive FDI scrutiny across Europe.
Great. So I want to thank all of our panelists here, each person adding something different to our perspective here. And I want to thank the audience. Please look for invitations to the next programs in our series dealing with topics such as dawn raids and information exchange. Please have a great rest of your day.
Thank you.
Thank you.